That was weird. Why'd it put me all the way to the corner like that? I don't know, chat. I don't know. Anyways, welcome everybody. Welcome. We are to the main event tonight. The main event. P. Diddy. P. Diddy is making rumblings in his filings out there. His lawyer did withdraw. We'll go over that tomorrow night on Thursday night show. But we are into Diddy filing a suppression motion. So now we're like, obviously this is one-sided, but now we're going to learn some things and like, I'm going to get some neat details out of this. I have not had a chance to fully read it yet, so I'm sure this will be good. I'm sure this is going to be good here. Need an extra 5 minutes to eat a sandwich? No, I did not. Oh. Well, anyways, guys, welcome to the show. I am Sean, also known as Potentially Criminal. I am an attorney in the Cleveland, Ohio area, known by Destiny as the Penny Lawyer. Also known by Nick Ricciardi, also known as by Jim Mediker as the fat guy Nick Ricciardi yelled at. I'm a man of many labels, of many names. You may know me by many names. But yes, we are getting ready to talk about what happened with Diddy. Stacy's what on earth's early crap? Yes. 2 outros tonight after yesterday's nonsense. Did I not? That was I forgot about that. I thought I did it, and I'm like, oh shit, I just clicked end stream, and I'm like, oh, that was embarrassing. Sean got the quartering. Like Jeremy got me. No, I got hand bleed. Next thing you know, he'll share the screen 100% of the time. Well, you just you just watch. You just watch, chat. Things can happen. Things can happen here, chat. So I'll pull this up here so we're ready to go. There we go. So sorry, I had to get that ready. He's also Clyde's dad, yes. Medicare is such a way of the words. Yes, he does. And speaking of Clyde, hey Clyde. I love how you can hear the click-clacks. Come here, buddy. I think 2.0's got treats because he's like, fuck you, fat man. It's like, all right, buddy. All right, Butterbear. All right. Fair enough, Clyde. Fair enough. It's good evening. How are you guys doing? So I'll give everybody a minute or two to catch up in here. Yeah, you can hear the click-clacks. That's what I love it when he comes scampering in. That's what Clyde's thing is. He likes to scamper. And you're just like, what's the deal here, buddy? What's the deal? What's the dealio here? And he just click-clacks everywhere he goes. And who is... Oh, let's somebody we know talking. So here we are. And this is, guys, a... hold on here. I need to scroll back for a second. I saw something. Where did I just see this? I just literally saw the thing and it disappeared on me. Frustrating when this shit happens. Frustrating when this happens. So let me tell you what. Let me see here. All right. So yeah, sorry guys. Sorry. It's what I hate with this damn thing. You're trying to set up Rumble and Rumble is not working. All I wanted to do was just have Rumble work. That's all I wanted for you guys. How's Stoney's chat? Stoney's doing fine. 4M, it's good to see you. It's been a little while. Hope you're doing well. And guys, trying to get Rumble set up here because I set it up and now it's not going live. And Rumble does this. This is the problem. This is one thing I will say about Rumble. You set up the live stream and then it doesn't do what you want it to do. And I don't understand it. You know, Rumble does so much that it doesn't Wait, hold on. Yeah, where is? Hold on here. Like, I literally had it, and it's just now, it just disappeared. All right, chat. Well, I guess we're not doing Rumble tonight. We'll work on that another time because it doesn't want to work, and if it doesn't want to work, I'm not going to fight it and make it work because it's just being difficult. It's just being difficult here. It's not worth the time. It's not worth the time to handle it. Oh, there we go. It loaded up finally. You guys should see Kevin Brennan struggling with Rumble this week. Well, Rumble has always been difficult. It's one thing I don't understand. You think they would have it under control because all I want to do is just like use your service. And why can't it just be like it's so in depth to set up a Rumble stream? I mean, like if you guys have never done it before, YouTube is pretty easy. You set up your channel, you're like, I want to go live, and they're like, cool, you can go live. You know, Rumble is even when you're doing Rumble. There we go. Rumble is up now, chat. And I'm just shitting on Rumble now since we're gonna shit on Rumble. Rumble, you have to go through like so many fucking steps. Like it's so ridiculous in what it wants to do and how it works. You're just like, come on now. Why can't you guys just work? Why can't you work? And it's like I said, Rumble is just redonkulastic. So we're gonna go ahead. We are moving on, chat. It is time to go. We are gonna do this. So we are gonna get into Diddy's suppression motion here. Ainsley says, we know Rumble sucks. We've been saying in the chat. It's all Viva's fault. Neo Dark Red says, because they want you to force you to use their studio. The problem is the studio sucks. Rumble does so StreamYard does like 85% of the things really well. 85% of things it does really well. The 15% it doesn't do or can't do is kind of sucks, but overall it's a pretty good product. Rumble does the 15% very well, but sucks at the other 85%. So that's where Rumble and StreamYard need to push, get their heads together. So here we go, chat. It is time to go. It is time to go. We've got this beast of emotion here. And this is it, chat. This is what we're looking at. This is the United States of America versus Sean Combs. I mean, you guys remember, that's Diddy's name, his real name. That's a government name, as they might say, depending on where you're from. That's your government name. So this is Diddy's motion here. And it was filed a couple days ago. And what's he doing? It's a motion to suppress evidence obtained through the search warrants, or in the alternative for a Franks hearing. Now, we've talked about a Franks hearing before, chat. Franks v. Delaware, that the police lied or relied on unrealistically and unnecessarily relied on clearly questionable evidence that they shouldn't have done so. So they were reckless in relying on it to get their case going. So we went through this. I mean, that's one thing I will say about the Nick's case. We learned, we got to talk about Franks. What is a Franks hearing? Now you guys know what a Franks hearing is, so we can do that and move on. So remember, they're arguing that either the police lied or they lied on evidence that was so poor that it was reckless for them to do it in securing the warrant. So Candace says, I knew Robert Barnes was involved. All right. Yes, he might have been. Well, yes, Diddy's already won. So they're asking for a suppression or a Franks hearing. Now, this is, it's 30 pages, guys. It's huge. So table authorities, introductions, factual background, argument. All right. So we got some things here that one of the victims, regarding victim one's consent and a financial motive. There's regarding credibility of other witnesses, that the misstatements and omissions were material. And the issue about the these warrants apparently were broad is what Diddy's going to argue. We're going to take a look at these. So here we go. So table of authorities, chat. These are cases where when you're citing a motion, especially in appellate practice, you have to list your authorities that you're using. This is like a works cited page. So Arizona v. Gant, Coolidge, these are, Franks, these are all pretty important search and seizure cases and search warrant cases. Payton versus New York. Payton involves a warrant going into a house. There's a lot of them. Riley versus California. Riley involves a cell phone. There's a bunch of these. And remember, chat, you're going to see like the Sixth Circuit. That's here in Ohio, Kentucky, Tennessee, and Michigan. But you also have the Second Circuit. That's where Diddy's at. So, but you also see a lot of Southern District of New York. You see the Eastern District of New York. So they're sending a bunch of things in the local areas. There's the First Circuit up in the Northeast, the Third Circuit, which is Pennsylvania and some of the mid-Atlantic states. So it's bouncing all over the place. They're also showing what you would cite as other authorities. So other authorities would be a treatise on the Fourth Amendment. So why is this Wayne R. Lefebvre? This is something that you would use to show, and is considered, we talked about this with the Miller and Wright cases, the Miller and Wright books in the Supreme Court for federal civil procedure. This is kind of like that. That's like the search and seizure Bible in federal court. It's a treatise on the Fourth Amendment, and a treatise can be entered into and relied on in evidence. Very in-depth, well-done scholarly work, like a treatise, can be used, and it can be read from. It can be used as an exhibit. I forget which rules for treatises. Which crap, I forget which. It's I think it's 803 something. I don't remember. Yeah, what's it say here? Come on, tell me what it says. YouTube 803.18. Okay. Learn. It can be used for impeachment, or it can help the trier of fact figure out what's going on. So that's why you're seeing that there. You might say, well, it's a book. It doesn't count. No, a book can be used. So they talk about the introduction. It says, the government has a duty of candor when it seeks warrants. Yes. Remember, duty of candor, not of duty of condors. The nature of the proceeding mandates secrecy, so the process is not adversarial. For that reason, investigators have an obligation to present a fair picture of the evidence, including both inculpatory and exculpatory facts. While investigators need not present a magistrate with every bit of evidence they have discovered, they must nonetheless include a reasonably even-handed account, and they cannot critical exculpatory facts that might undermine a finding of probable cause. And the Second Circuit has instructed that investigators should include evidence, even if it's the kind of thing the judge would wish to know, in determining whether probable cause exists. The government utterly fails to do this here. They sought several warrants to search Diddy's residence, his devices, and his person, and presented a grossly distorted picture of the facts. It included only inculpatory facts. It excluded critical exculpatory evidence that was indisputably in its possession at the time. The government claimed victims were coerced into sex, but failed to inform the magistrate that something happened here. And I'm sure this is mentioning something about him getting probably having permission from victims, or something that's in the sealed, something that's in discovery that's not been allowed to be publicly disclosed yet. Because this isn't like a terrorism case where you're dealing with national security things, but there are things that are going to be sealed and are not allowed to be discussed. So this gets filed, but the court also gets the unredacted copy. It also failed to inform the magistrate that it possessed text messages between the alleged victims of Mr. Combs that probably talk about consent. Or it's another person they're talking to. The applications were misleading, which at a minimum requires a Franks hearing. The warrants themselves were grossly overbroad. On a theory that his entire life is a criminal enterprise, the government sought virtually limitless authority to seize any evidence related to that enterprise. All his digital devices, the information they contained, all information on his iCloud, plus troves of records and items in his house, almost none of which was contraband. And they say, and they talk about in the case here, United States v. Way. Do you know the way? Where Judge Nathan found a similar warrants unconstitutional. Here, the government obtained authority to rummage at will through its private effects. And this is cited in Arizona v. Gant. You can't just rummage through as part of a search incident to arrest. You got to have a limit to it. Perhaps most troublingly, the government received limitless authority to search digital devices which contained personal information. And the Supreme Court and the Second Circuit have warned that it's important digital device searches must be limited and particularized. So it sounds like they just got, we want to just hoover up all the data on his phone, which they probably got a warrant that says you can just mirror his entire phone, which I don't like it when they do that. I don't like it when they do that because you shouldn't be able to do that. Mario's saying the table authorities isn't necessary in trial court practice in the SDNY, so they're just they're just showing off to be fancy. I didn't want to say that because I don't know what the trial practice was in the SDNY, but there we go. It looks good. And believe it or not, chat, there's a lot of things you'll do that look fancy, and you're like, it's kind of like what movie is it where the guy, the girl's getting the facial done, and they put cucumbers on her face, and he's like, do you know what these do? And she's like, no. He's like, absolutely nothing, and he eats one. There's a lot of dog and pony show in the law, believe it or not, chat. Believe it or not, that's a very common thing here. But let's see where they get to going on this. So these warrants were not. The warrants were thus unconstitutional and general warrants, and the evidence obtained must be suppressed. Yes, chat, and remember, the warrants must be particularized for a particular place, for particular things. And, in the case of a phone, like, we're only looking for such and such data. And they say during its investigation, the government executed numerous search warrants, and that's good. They didn't just do one. On January 4th, it received a warrant to obtain all of Diddy's iCloud accounts. Okay. On March 22nd, it received 2 warrants to search his residences in LA and Miami. Both applications were based on substantially identical affidavits sworn by HSI Special Agent Sean Quinn. Now, this makes sense that they would probably be the same thing because it's the same set of crimes, presumably. That's not really the issue there. But I think they're trying to introduce this to make the idea that they basically just changed out the name, they changed out the addresses alone, and that both warrants are bullshit. So it's 3 days later, the government obtained a warrant to search Diddy's person, which means they probably took some DNA. And I'm betting they had to photograph him, kind of like the whole Michael Jackson thing where they took a picture of his penis. I'm assuming they took some pictures of Diddy for verification purposes and to search 2 of his cell phones. They say the paragraphs are to the Los Angeles warrant. The same information, and as I was right, chat, the same information with minor variations is presented in the Miami warrant. So there you go. It's like I have an idea of what's going on here. It's like I've done this before. The warrant sought to obtain evidence related to possible crimes of racketeering, sex trafficking, and obstruction of justice. The list of items to be seized was incredibly broad, spanning pages and including, among other categories, all digital devices found within the residence. Well, does that include your Alexa? Does that include if you find like any digital device? Think about today, chat. How much crap do you own that's digital? Now think about somebody like Diddy. That's going to be a lot of digital shit out there. A lot of digital garbage. Let's see here. James Owen says, who had extracted DNA? Well, not like that. Not like that. They did a cheek swab, but they did a DNA test or DNA warrant. So the list of obtained information, was similarly broad. But as discussed below, the warrant applications presented a grossly distorted picture of reality. The government had in its possession, for example, a variety of evidence, including blank, 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 which they won't tell us, suggesting victims' one participation in the freak-offs was voluntary and consensual and not coerced. So I'm assuming some sort of text message, some sort of message data. The government claims blank, 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 and we don't know, probably once, their claims of some warrant action was based primarily on statements from producer 1, an utterly unreliable witness whose claims were contradicted by other evidence the government failed to mention. And the government's obstruction allegations were based largely on text and statements taken out of context. A critical part of the context being that something Diddy said was blah, 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 which sounds like it would be, it sucks we don't get to know everything here, but at least we're kind of getting an idea that they're claiming a lot of shit is not done right. The affiant also failed to mention that nearly every witness he interviewed had, and probably, I don't know if they had an NDA or they had something there or they had lawsuits pending I think that's maybe what they're arguing here. Who knows for sure? We have to guess right now. Giving them a financial motive to fabricate or embellish. The probable cause statements were misleading, but it worked. The government got its warrants. Leaking damaging information, which they did. They did leak information, and the government got caught leaking information through the investigators. Like, that part is a big problem. That part is a big problem here. Somebody saying there's too many Seans at once. Yes. So through this duplicity, the government obtained evidence, including multiple electronic devices, with an enormous amount of information about his entire life, an enormous and unfair tactical advantage. It continues to press the advantage, obtaining an indictment through multiple and additional warrants, which were also incredibly broad. So we're actually getting to the argument now. The warrants may not omit critical exculpatory evidence. This is under the Fourth Amendment. A warrant may only issue upon a showing of probable cause. The warrant clause is not merely a probable cause guarantee. Rather, it's a guarantee that a warrant will not issue unless a neutral and disinterested magistrate independently decides that probable cause exists. And if you guys want to know, as then Judge Barrett, yes, that Barrett. What did somebody send me here? So that is why they're talking about it. And you're trying to sound fancy. You're like, look, even the Supreme Court justice has got our back, Judge. They say a magistrate can only perform that function if the government provides an accurate and complete statement of the evidence demonstrating probable cause. No, we're back to Franks v. Delaware again, chat. It's like everything old is new. If a statement of probable cause contains material false or misleading statements, then the warrant is invalid, and the evidence obtained must be suppressed. To suppress evidence pertained pursuant to the warrant, the defendant must show, 1, that the application contained intentionally or recklessly misleading statements or omissions, and the falsehoods were material and necessary to the warrant's issuance. So you got to show that, because if it's intentionally lied and it doesn't matter, or you're reckless and it doesn't matter, well, then it's not important. It has to be both, either reckless or intentional, and then it also has to be material and necessary to the warrant's issuance. Now, I think it should be period. If the cops fucking lie, they shouldn't be allowed to intentionally lie. There should be punishments. They should be forced to tell the truth all the time. But what do I know? What do I know? Oh, BCM over in Rumble says those Sean people use caution. Yes. And they say to obtain a Franks hearing, a defendant need only make a substantial preliminary showing as to each prong. Yes, you don't have to prove it. The reckless or intent may be inferred where the omitted information was clearly critical to the determination. And they say, as noted, a warrant application can be false either through the affirmative false statements or misleading omissions. The application must contain a reasonably complete statement of the evidence, including exculpatory evidence, that would be critical to the evaluation of probable cause. And they say, though an officer doesn't have to need not volunteer every fact that arguably cuts against the existence of cause, the officer may not omit circumstances that are critical to the evaluation of probable cause. And they say, well, an application need not include every potential evocative detail that would interest a novelist or gossip writer. An investigator cannot make unilateral decisions about the materiality of information. And now they're pointing out here that it's not your job as a cop to determine what's material. It's very much like when it comes to evidence, kind of like the Alec Baldwin thing. Well, what's important evidence? Well, we decided it's not. It's not your job to decide what's important and not important. It's your job to turn things over. It's your job to provide information. So here, this is a similar situation. It's not your job as a cop to determine what goes in the warrant, like what's in the application. Include it, and I'll decide how important it is. Oh, who is messaging me? What is this? Okay. We'll get to this one later. Thank you, Luke. It says merely inform or merely inform the magistrate judge of inculpatory evidence. They say simply put, the affiant seeking a warrant cannot withhold important exculpatory evidence from the magistrate. The duty to include critical exculpatory evidence includes a duty to reveal information that undermines the credibility of a witness or CI. When the government relies on the statements rather than investigators' own observations, their credibility is plainly relevant or even critical to the probable cause determination. Oh wow, it's kind of like we just saw something there that pointed out one of the arguments previously made. In Nick's case, felted by the Second Circuit. The failure to provide information that goes directly to the credibility of a witness or informant violates the duty to disclose. So the government made false statements and omitted critical evidence in this case. The omitted evidence was in the government's possession at the time it sought the warrants. The omissions were intentional or at the very least reckless. So now we're going to talk about victim one's consent and financial motive. The core of the allegations, indeed the government's entire case, is that Diddy forced victim one, and that's interesting. The entire warrant is about victim one, like mainly about victim one, to participate in the FOs, the freak-offs. In its warrant applications, it stated that victim one stated about probably being in the freak-offs and was forced to do them. This was based on the investigator's interview with victim one, which took place 5 years after the events. Ooh, that's interesting. So this is like 5-year-old stuff. That's very interesting, chat. That's very interesting here. 5-year-old information. Doesn't mean it's not bad. But the longer in between, there's the longer time in between when you disclose, the police learn and take notes, there's going to be a greater and greater likelihood of somebody saying, like, are you sure you're true? That's a problem here. It's not fatal, but that is an issue. Like, how long when was that included? Was that included that way? We don't know. But the government unaccountably failed to inform the magistrate of blankety blank blank blank, which severely undermines its account. So it must be in the interview or statements of someone else that's available. I mean, if this stuff is true, that's a problem. So when it sought to search and warrants for Diddy's residence, the government had already obtained device one from victim one that contained probably information from Diddy. And here we go, chat. There you go. Black bars of transparency. Now, this is being done because it's all under seal still, and probably some of that's for Diddy's benefit. And this is by a Mark DeGaragos declaration. Say, unbelievably, the government did not, in the applications, or even inform the magistrate about this, whatever this is. So there must have been a massive disclosure of information here. I mean, think about how much writing that is. That's all factuals that's covered up and redacted. Faced with a claim of coerced or forced sex, and it's probably talking about some sort of consent, is the sort of thing any fact finder would wish to know. So it sounds like the government may have hid issues and concerns about consent. So, unlike Destiny, it sounds like there is consent here. By the time it obtained the warrants, the government had also already obtained and probably this information regarding consent. Which, yes, if you find information that can counterfactually countermand like information you got in your warrant, I mean, I would tell police you don't have the authority to run that warrant anymore in the interest of candor, because remember, the police are going before the court. You shouldn't execute the warrant if you know there's a problem. And he says, once again, these probably allegations of consent contradict the government's claims the FOs were coerced. So there's probably other people saying that it was, or maybe even victim one themselves has said this. More and more and more, this is blocked out here, so nothing you could do about it. So, and there's more here. Redacted. redacted, 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 redacted. We'll get to this pretty quick, chat. Redacted, redacted. But here's the thing. This is the part that's bad, though, for the part I did see. The government alleges, but it failed to mention. The government alleges blah, but it failed to mention. Well, that doesn't help us because we don't know. But from up here, we can at least discern. It sounds like they have either victim one stating that there is consent or consent is not clear, meaning it's like if it's not 100% like clear that he just forced them, then there's some doubt as to like, was it consent at all? Was it unconsensual? Was it not consensual? So yeah, it looks like there might be something here, but we'll find out as the case progresses. Moreover, and they talk of this must be the producer issue here. As their relationship deteriorated and the two managed to break up, it sounds like Diddy and victim one had some conversations. And it sounds like there may have been more conversation. Like, look at all this, like a lot of information there. They are important evidence, and presumably they show the context of relationship. They're the kind of thing any magistrate would wish to know when receiving an application in a sex trafficking case. So it sounds like Diddy or his people had a relationship with victim one. So that actually tells us a lot as to what we're looking at here. JMK, how you doing? Jefferson Post says it looks like it's pulled from a Soviet library. Well, okay, look, I get that, but they have limitations. There's protective orders and things in place by the court. You have to follow them. I'm sure they'd love to let this spill out and show the world how shitty this went, but they can't do it. They can't do it. But it looks like we're in a situation. Could dead people consent? No. But it does show us, it looks like there's something here about these people being involved in a relationship, which kind of implies, there's going to be belief and consent there. The warrant applications don't contain this relationship information. They didn't contain any of this at all. They simply stated that, and it's probably some issue that was involved and, stuff happened. Without that, this was intentionally misleading. And then they're going to talk about something else they have. And it's probably victim one's statements contradicted victim one's later accounts and gave the investigator obvious reasons to doubt the veracity. The investigator was legally required to disclose them. Now, this is problem here where you get to this part here, chat. We can't read this. It's not going to help us. They talk about the government hiding more evidence. Can't really do anything about it. They do talk about a male escort service. And as far as the motion to miss count 3 details, the service has been operating in the open for over a decade. So for number 3 here, they're going to talk about bringing in male escorts, and probably in the search warrant, they talk about, the forced trafficking and the forced participation. They hired male escorts. Sounds kind of gay, but what do I know? What do I know? They also point out that apparently Diddy had discouraged this person from using so many drugs. I assume we're still talking about victim one. And it says, finally, the warrant contains no mention of victim one's financial motive to exaggerate and falsify. And they're going to say, as the government knew, and it likely means there's some sort of lawsuit going on. There's probably some victim number one's probably one of the people who's filed a lawsuit against Diddy. And they're probably redacting a lot of this because it's been ordered by the court. You have to redact this information. So presumably this is part of a lawsuit somewhere that's pending. And it says, thus providing an unusually strong motive to fabricate years after the underlying events. And remember, guys, that's always a sus thing. When it's like how many years pass. It's one thing if you're a kid and things happen. But when you're a grown-ass adult, like, yeah, that's a thing there. And it looks like this is more about victim one. It says, years after a relationship, she changed her story in a way that caused maximum damage to Diddy and thus give him maximum incentive to agree to a large payment. Well, I'm sure the Cassie Ventura thing helped out too. Watching Cassie Ventura get a big old frickin' check the day after she files a lawsuit. Victims one's suit was settled the next day, from my understanding. It could be. I mean, and maybe that's who they're talking about is Cassie Ventura. Because remember, Natasha, Cassie Ventura's was settled the next day after she filed. She filed and Diddy cut her a check. That was a smoking hot settlement. So I wonder if Cassie Ventura is victim number one. So I think that could be correct. Cassie Ventura might be victim number one. Because she was in a relationship with Diddy, and it was years afterwards. And says this is exactly the sort of evidence that goes with credibility of the witness whose story provided the core of the government's applications. Which is interesting. So Cassie Ventura's, I'm betting this is Cassie Ventura, guys. Remember, this is the woman Diddy dragged down the hall by her hair and started whooping on her. She's probably victim number one. Isn't that neat how you can kind of figure out things just by knowing the information? We're like being detectives. Cassie was a major victim. Yeah. Yeah, Cassie is victim number one. Probably is. Anderson Cooper says the woman who Diddy beat changed her story after she escaped. You don't say. Well, there's that too. You're like, wow, no duh. She's gonna like. Oh, that's a total thing. There. I agree. That's a very interesting point there. They say as courts around the country have held, evidence undermines the credibility of a key witness must be revealed. The magistrate must be given the opportunity to assess the totality of the circumstances. And say, rather than giving the magistrate a fair summary, the government hid exculpatory evidence to bolster its case. They were calculated to mislead in clearly critical evidence by omitting it. So they talk about the exculpatory evidence regarding the credibility of other witnesses. So the government sought victims one's allegations and made related allegations from other witnesses. Again, the government had evidence undermining the credibility and presented misleading and selective accounts. And they say, we are not dealing with the omission of a few ancillary facts. This is a case of systematic deception. So I talk about sex worker number one. And they relied on sex worker one's information, talking about being at the freak offs is probably what this is talking about. And everything transpired. They talk about there's exculpatory information which was not included in the warrants. And in its discovery letter, and discovery letter is what the government provided to defense, the government revealed that and probably some exculpatory information was disclosed. Now they talk about footnote number 5 here. The government has refused to provide the defense with the names of the anonymized individuals named in the warrants. Sex worker 1 appears to be the person described in the letter. So they don't even have the names of the people. They just know them as initials or their what's going on out there. Think about how tough that is to do a case when you just get those. And these statements from a key participant in the freak-offs undermine the allegations, and I think it's going to be undermining the allegations that there was consent involved, or there was no consent involved. And they corroborate probably the idea that there's a lot of consent and stuff in Cassie Ventura's phone. It's unclear when the government received the information, except it's something that any investigator would have asked. So probably more contradicting evidence. And they say it's also unclear what other exculpatory statements sex worker made about Diddy and probably who else was there. And they says this is why a Franks hearing is required to learn more about what the government knew and when. And if the government was not aware of and probably the consent issues here, it would have been aware if it had asked. And this is the motives of the other parties. And they say, given the loose relationship with the truth throughout its warrant, the most obvious inference the government was already aware of sex worker 1's exculpatory statements, but failed to include them. It did exactly what the Second Circuit forbids, just merely informing the judge about inculpatory evidence, meaning evidence that leads to guilt. Remember, exculpatory evidence allows them out, and it tends to show no culpability. Tickle says almost 3 a.m. here. I'll check back in 2 hours. When the response that smacks all this down when Black Bars comes in. Well, good night, Tickle. Thank you for being here. Oh, is Alyssa Mercanti the sex worker? Ah, that would be something, huh? Wouldn't that, chat? That would be something if it was the case. If that were the case. Something tells me it's not the case. So the warrant relies on information about Assistant 1. Now, is Assistant 1 the guy who got caught with all the drugs, his drug dude? That's going to be an interesting issue here. As with Victim 1, the applications fail to disclose that. Probably something about Assistant 1 has some sort of monetary issue or bias issue towards Diddy. The applications were particularly misleading in their accounting of the supposed obstructing of justice. They stated Diddy obstructed justice by, and they lay it all out, but the government cherry-picked a couple of statements out of context to imply probably something about destroying evidence or interfering with the witnesses. But they say the complete thread demonstrates the opposite. So it's a thread. So this implies it's probably some sort of like text message or group text somewhere about what's covering it. But we don't know because it's a big redaction. That's okay. We can do it. This is not a harassing or threatening exchange. And it sounds like it's more about Diddy probably just venting or frustrating. And it does not remotely make out probable cause for an act of obstruction. And it says, but the government plucked quotes out of context and presented the magistrate with the distorted picture of what happened. The distortion could not have been accidental. It was a deliberate choice. Interesting. Talk about producer 1. Some of the most salacious allegations recounted in the warrant came from producer 1, who the government now says it will not even call to testify at trial. Okay, that's a big problem. That is actually a very big problem here. That is a massive issue. They called in a witness, and I didn't know this. So they have somebody in the search warrant provides information, and they're not going to call that person as a witness. Why not? What that's a little sus to me. That's a little sus. Sounds like some of that information didn't pan out, maybe. I wonder if that's the issue. This guy, they say salacious. I wonder if he spilled a lot of tea and then it turned out there was nothing there. Now, here's the thing, chat. Just because you execute a search warrant and don't find anything does not mean the warrant was bad. It's a search warrant, so they're not guaranteed to find stuff. I know, for example, I was involved in home. I helped review a search warrant, and they hit the house, and they apparently the guys who were doing the drug trafficking had a system where they kind of shifted the package around a lot. They didn't let the package stay in one place because they were worried about getting busted. So they moved it to another dope house, and they moved it around, and like a couple weeks later, they caught the guys moving it. So they hit the house and nothing there. Or he could have been threatened and refuses to testify. That wouldn't be enough. The government has decided not to call him, probably for the reason of whatever he said didn't pan out. Or it may have been for who knows. We don't know. Maybe he was on the government list to testify, and then they took him off the list to testify. We don't know at this point. We don't know. Something's different here. Something's different. The investigator indicated he had interviewed one, and producer had relayed his stories about working for Combs. Producer explained, among other things, that, and he probably made a bunch of salacious shit here. Probably the most serious allegation was his claim that something occurred, probably involving minors. The application state, and they probably talk about Diddy allegedly having, minors, because that's something Lil Rod included. These accusations were never credible. They were uncorroborated. And the government had boatloads of contrary evidence, including probably other statements. And it's interesting, he says, the government dropped these allegations in later warrants, but their lack of credibility was manifest from the outset. Well, and that's the thing. If the government learned later what they had relied on wasn't valid, yes, they should take it out. But Mark Agnifilo is saying, you knew they were bullshit when you did it, and you had to corroborate the contrary evidence at the time. So this is getting interesting. This is interesting here, what's being alleged. This is very interesting. This is interesting. The government once again didn't disclose the financial incentive to fabricate and embellish. I wonder if this is talking about producer one giving interviews or like a book deal or something to like Us Weekly, or was being paid for a story. Probably something like that. The government has advised us it will not call producer one as a witness at Diddy's trial, presumably because his stories are fantastical and he lacks credibility. But his lack of credibility was equally apparent in March of 2024, in part based on, and he probably says some crazy shit about the psychic vampire potbelly goblins who are coming around after us. And at a minimum, the warrant application should have disclosed that he was a fucking psychopath. Mainly his motive to fabricate and tell the government a story that matched the stories of, and it probably talks about the other people they relied on. They say, once again, however, the government hid this from the magistrate. The investigators simply relayed producer one's claims without qualification as if he were a credible witness. This is interesting. This is interesting here, chat. Was producer one Alex Jones? I don't know. Chat. I don't know if he was Alex Jones. But real quick, chat, we got to get to this real quick. Nisa Natick gifting 10 subs. You know, chat, he is doing his part. Are you doing your part out there, chat? Are you doing your part?
Fight for the future.
I'm doing my part.
I'm doing my part.
I'm doing my part.
I'm doing my part, too.
They're doing their part. Are you?
Yeah, are you doing your part? Something to think about. Something to think about, chat. Something to think about. And Nisa Natick also met a member for 4 months. Thank you for the support and your generosity. He says the main event is purging the grays. That's right, chat. Purging them with holy fire. Purging the grays. Christine says hello from Michigan. Hi, Christine. Hope you're doing well. Yes, KJ is right. Service does guarantee citizenship. Oh. Okay. Gray with a hard E. Not the soft A, the hard E. Oh. Victim number 2 probably made up a bunch of things that there are problems here with. They didn't go talk about. Victim number 3, the affidavits alleged, based on interviews with victim 3, that Diddy probably, once again, forced them to do stuff or other things happen. The relevance of these is less clear. The claims about victim 3 appear under the header. And I wonder if this is where this victim is not alleged to be as involved as the other things. But we don't have the full information here, so we can only speculate. In any event, the warrant applications once again include none of the information the government must have known that called into question her credibility regarding the allegations, which is interesting. So the government knew about some issues. And once again, none of this information was necessary to assess her credibility was included in the warrants. They talk about victim 4. And the allegations probably were ones that were incorrect or fantastical, maybe. They went on to state and they said there is no effort to corroborate her claims. If it had done more information or investigation, it would have conducted evidence contradicting her account, which this is where apparently other victims and other evidence or other witnesses would have contradicted her. And it says the applications also failed to note something significant here. The warrant applications included allegations from designer 1. So some sort of designer. I wonder who that would be. Like, it could be anybody. The government also claimed a representative Diddy had engaged in obstruction when And they're talking about something happened here, what Diddy and his people had done, but who knows if that really was obstruction. They talk about the three critical witnesses the government relied on were all probably plaintiffs in lawsuits where they each sued the defendant for significant physical harm that was alleged to have happened, is probably what they're saying. Not only do they have the general motive to fabricate, but it's probably also these people had given interviews or made themselves available to the press, something like that. Who knows? That information would have raised doubts about their credibility. But the government said nothing about probably these lawsuits being filed. This is once again an intentionally hid evidence that would have undermined the credibility. So this is actually very interesting, chat. This is interesting. It's very, very interesting. We should play Mad Libs of those redactions. No. But it's very interesting. Earl's saying, what are the use case redactions in this situation? Well, I'll bring it up here so you guys can see it. Because there's gonna be protective orders and limits to what can be disclosed in this case, and that's not abnormal in a case like this where you've got victim confidentiality. There's a lot of things here that the government's going to try to have other stuff sealed up too anyway. They're going to argue protecting tactics, techniques, and procedures and investigatory methods. But we are going to look this up here. I forgot. I looked at it before and I forgot to bring up the pacer. So we'll take it here, chat. Diddy defend it? Nope. Wrong case. Ventura v. Diddy, no. USA v. Diddy, no. That's the one we need. Here we go. Nope, not that one, not that one. Guys, when you put Diddy and Pacer, he's like, he had a lot of shit go down. You're like, oh my God. He's been sued everywhere. He's been sued all the time. Wait, why is this? I couldn't. Oh, hold on here, chat. We're going to court listener. Court listener will be easier and it'll be cheaper. Because it's free. Hold on. Wow. There's a lot of people named Combs sued in federal court. That's not good. That was interesting. There's like, your search turned up 85 million cases. Let's try it with just one. Let's just try it with one. Where is... Oh my God, I forgot all these people sued Diddy in 2024. It's like, it's so ridiculous. This is not... I wanted to bring you guys the actual thing here so you guys could see what's going on. Why is this fighting me so hard? Filed after... Hold on, chat. There we go. That should fix this up. That should fix this up. Oh, come on. Goddamn court listener. Everything's searching out for it. Saying it's busted. Yeah. Well, no, that's not it. I wanted to show you. His full name is Sean John Combs. That narrows down the amount. No, because it just says USA v. Combs when I was looking through stuff earlier. I just don't... Where the hell did it all go? But anyway. Yeah, I think it's crashed. It's like, it's not searching. It's being completely retarded, chat. It's being completely retarded. Which is frustrating because I wanted to go through this with you guys. And it's just being completely redonkulotastic. Which sucks because I wanted to show you guys there's protective orders in this case. There's going to be saving what's going on here. Where is... Yeah, we're not, hold on here, chat. Why am I doing this? I'm an idiot. All right, hold on. This would make a lot more sense. Why don't you just copy and paste the case thing out of here and use that? That would make a whole lot more sense, wouldn't it? It's like I'm not being an idiot and I could just do it this way. So that would have made a lot more sense, wouldn't it, chat? Wouldn't have made a lot more sense here. All right, so now we're moving on to this. We're moving here. This is going to be... Can't you paste her using the docket number? Yeah, I did. I wasn't thinking about that, Mario. I was completely stupid. And then I'm like, oh, I can cheat and use that. Because all you do is just scroll up here and throw it in, and now you're set. All right, chat. So here you go. There's a sealed redacted indictment. Okay, but there's also other things that happen here. They are seeking to protect things that are done. And just going through all of this, this is addressing everything that's happened in this case. But this is the result of a protective order. And I got to see, where is it? Yeah. So this is from the AUSA. They're seeking a protective order here. And this is the letter of motion from the U.S. Attorney's Office. And they want to protect what's going on out there. Because there are things they want people not to see in what's going on. So they're seeking a protective order. Both parties respectfully request the court enter the order. And that's why we're having stuff that's done this way. Both parties want it. And even then, that doesn't automatically mean you're going to get a protective order. But it does help because they're pointing out, like, look what this is going to do. This is really bad. This is kind of rough. So both parties have asked for it. And now what they're going to do with this. And this will help you guys just so you understand what the protective order is. This is the actual protective order that they agreed to. So this is the protective order filed back in October. So they are going to do things here. So the government will make disclosure of things, but the government may include material that affects the privacy and confidentiality of individuals. And they're worried, like I said, they have concerns about stuff leaking out, but Diddy has that concern too, because this would be bad. But it affects the privacy and confidentiality of individuals. It might affect ongoing investigations of other people. It would risk prejudicing pretrial publicity and may be produced with more limited redactions than would otherwise be necessary. So they're asking for things to be sealed. They're asking for things to be redacted. So anything that could lead to the identification of a witness who might be subject to intimidation or obstruction, their lives, persons, and property, as well as the lives of others. So that's why we're seeing a lot of that being redacted, because if we didn't chat, there's a very good likelihood we could figure out who the hell these people are. And if we couldn't figure out who these people are, it's very likely that Diddy and his people could figure out who these people are. It's a very likely thing there. I went to court listener to say 10 cents page. I went to court listener because Pacer was acting all retarded. Every once in a while when you use a Pacer and you search, it just bogs down. So that was more of the issue there than anything. So yes, I'm sweeping for Diddy, chat. That's what I'm doing. But this information here would make it very likely you could tell who this person was. I'm betting we could easily tell who these people were, or at least people out in the press or in Diddy's community or in the hip. Like, there would be ways to identify these people. But more importantly, I'm assuming a lot of this shit Diddy doesn't want us to know about anyway. Like, think about it, guys. Diddy doesn't want us to know about all this crap happening because this is private life. So they both have interest in keeping it sealed. So you guys were asking, I forgot to bring out protective order earlier, but there's a lot of reasons why they do it. So, but they talk about the misleading omissions in the warrants are frequent in pattern. The affidavit example, all information about all the witnesses' lawsuits. I mean, think about that. Like, let's type out. Like, think about, this is a little bit bigger of a font, but look about how well that fits right in there. Look how well that fits. Look how well that fits, chat. It's probably what they're talking about, their lawsuits. The victims, their lawsuits. Think about what fits right there. And their financial motives to fabricate. So I think we can agree that's probably what's going on there. Probably including their lawsuits. Kay says, how much do I pay to pacer each month? It depends. Sometimes a lot, sometimes nothing. I don't do federal practice, so it all depends. So that is what we're, sorry, just reading what you guys were mentioning there in chat. These omissions were related and exculpatory, indicating recklessness. This is a case where the cumulative effect of all the omissions was to nearly eliminate every indicator detracting from reliability. And they say this is a case where the affiant failed to provide all potentially adverse information that might have undermined a probable cause finding. Now, you guys see when they're doing this part right here, this quotes, that came from the Riley case. Where the quotes are here came from the Simmons case. But they're basically chopping up those quotes and fitting them into sentences saying, this is the same thing that happened here, and these cases have all said it's bullshit. The law requires the government to include all critical exculpatory information in an application. Here, the government included none. That's true. That's not good. They point out that sex trafficking, like cheese pizza, is so repulsive a crime that those entrusted to root it out may, in their zeal, be tempted to bend or even break the rules. They say when the government cheats to obtain warrants, they endanger the freedom of us all. Very true. Cops who lie on warrants are a bigger threat to society than Al-Qaeda could ever hope to be. And if you guys have never been here before, I'll say it again so you understand. When the police lie like this or abuse the Constitution, they're a bigger threat to your life than Al-Qaeda, the Russian government, or any other people out there that are bad men will ever be. Will ever be. They say, when government investigators cheat to obtain warrants, they endanger the freedom of us all. In cases like this, it's essential that courts enforce the requirements of the Fourth Amendment, both to protect the individual defendant's rights and also to deter this sort of government misconduct. And now they're saying that these were material omissions, that they contained falsehoods and misleading omissions. The remaining question, the second prong of Frank's, is whether those falsehoods were material. This analysis examines what a hypothetical truthful warrant application would have stated and whether that information would have supported probable cause. In the case of misstatements, a reviewing court must set aside the misstatements and determine whether the untainted portions are sufficient for probable cause. And that's true. You have to gut out the misstatements, and do you still have enough probable cause on a warrant? Very much like we did with Nick Chat when the argument about the Children's Services case. Remember what I did? I took out the redacting. I turned on the highlighter and made it black. And we redacted everything talking about kids. And what do we have? A drug warrant still. So if you can remove everything from the warrant and you still have enough, then it's enough. They're here going to state that victim one's relationship with Diddy probably happened here, but they'll also state the relationship was long, often complicated, and often loving. They also would have stated that blank, 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 blank about the relationship probably between Diddy and Cassie Ventura. And they say such a presentation would not have provided probable cause for a trafficking charge or any federal offense. Still less, it would have provided a basis to search everything and in anything in Diddy's two residences a decade later. And that's interesting. They didn't mention, though, you heard us talking about the 5 years between victim one's account experiences and then her interview. So we're talking about over 10 years later, 10-year-old information. That's a bit of an issue, chat. That doesn't mean it's automatically invalid. A 10-year information does not mean it's not invalid. But that's something. That's not nothing. That's not nothing. There's a there. It's just how big is that? How big is that thing? 10 years is a lot of time. And you're getting probable cause off 10-year-old information? I mean, ooh, buddy. That's got my ears up. That's got my ears up. 10-year-old information in the warrant. That doesn't mean it can't be invalid. But God, 10-year-old information is sketchy. That's a bit sketchy, man. It's not like they just experienced it. The truthful application would have stated that Diddy, and it's probably talking about with his producer, probably had a falling out over something. They would have stated producer one probably threatened Diddy for a lot of lawsuits. And they, there probably was attempts to shake him down. They point out the truthful application would have stated a bunch of stuff. They would have noted some of Diddy's representatives probably did stuff on their own. So, and it says, the government here unfortunately demonstrated a damn the torpedoes, full speed ahead mentality. The words of Admiral David, or actually he's probably Commodore at the time, Commodore David Farragut, when he stormed Mobile Bay during the Civil War, leading the Union blockade. And they didn't have torpedoes back then. They were basically mines, but they called those torpedoes. But yes, he said, damn the torpedoes, full speed ahead. David Farragut's kind of like John Paul Jones. He's a very foundational figure in the U.S. Navy. They say, in its zeal to prosecute a famous target, it rushed ahead and violated the law. It submitted an egregiously false and misleading summary of the evidence, thus denying the neutral and disinterested magistrate the opportunity to independently determine whether the probable cause exists on a fair and truthful summary of the evidence. It presented only inculpatory evidence and hid all the exculpatory evidence. The falsehoods taken in the aggregate were material to the probable cause determination. True and complete applications would not have had the probable cause to search both of the residences and all of his devices. Now, it's interesting here because it's the way you word this, I think, is a problem if you're in defense counsel. Because now you're saying when you say this, it almost makes it sound like the warrant could be for like partial investigation, which I know what you want to say. The whole thing is bullshit, but this thing, truthful and complete applications, would have provided would not have provided probable cause to undertake anything done in any of the warrants. That's what you probably want to say. Doing it like this is saying, well, you're not saying I could search both of them or all of his devices, but you're saying maybe one residence and maybe one device. I don't think you want to do that. I think you just want to say period. I just think this is a very verbose person trying to say things, and it's far better to just say, no, you wouldn't have been able to get a goddamn thing, period. That's just me. That's what I would have preferred. That's how I would have wrote it. Jefferson, yes, and this is the other point. How likely is the thing you're looking for to be in the same place it was 10 years ago? Yes. How likely is that evidence still to be valid? And that becomes an issue. And that's not there. It's not clear. And that's a bit of a concern for me. Yes, torpedoes used to be mines. Are they accidentally giving the judge a chance to split a baby? I mean, you're kind of making a not clear argument, which is never good. Mario says, yeah, not both of, but any. Agreed. Yeah, and that's the thing. So that's the issue here. That's the issue. Pam Bonnie says the Epstein files will be released tomorrow. I'll believe it when I see. Oh, here, chat. You know what's going to look like? Here you go. Here's the Epstein files, chat. Here's the Epstein files. Hold on. Here you go. Yeah. Here's the Epstein files. Where do we have that whole page of it? Here you go, chat. Here's the Epstein files. Here's what you're going to see. Here's what you're going to see. Calling it now. Is there somebody outside? Here's what you're going to see, chattel. I'm telling you right now. Here's what you'll see. Hold on one second, chat. Oh, okay. Somebody was outside. I was like, I thought I heard people outside, but I wasn't sure what the hell's going on. So the car door closed and Lane starts barking. I'm too young to be so pessimistic. Don't you worry. This happened way before I became an attorney. I'm sure all the paperwork's going to burn up tomorrow. Or when they were feeding it through the scanning machine, it'll actually, you know what's going to happen? Here's what's going to happen. Pam Bondi's going to come out and say, look, guys, funny story. When we were feeding in all the Epstein material and we were putting it in the high-speed scanner, it turns out it was a shredder. Huh. Oh, no. Like, duh. Big oopsie. Sorry about that. But trust us, it was good info. Trust me, it was good info. What about the backups? Oh, I mean, and when that happened, there was a fire. There was a fire. Could you believe it? And then, we had another intern. He was drinking a coffee and he spilled it on the computers. And they just went, zzz, and she's like, I'm not a computer guy. They just tell me it doesn't work anymore. That's what's going to happen. That's what's going to happen. So you can laugh all you want. I'm telling you, that's what's going to happen here. This is what you're going to see. It's going to look like anything the CIA has released. Although I hope they do it like this and not just make a solid black square, because that's being lazy. Actually, redact your lines. Have to work for it. All right. Now, moving on from here, chat. Aquila is saying the fire already happened the moment they were filed away. Well, that possibly too. That'll possibly be that too. Yes, it was actually a shredder. I know. That's what they're gonna be like. I thought it was the scanner, but it was a shredder. Sorry me, silly me. The stupid IT guys didn't confirm the backup tapes were working. I know, just everything breaks. Everything breaks. Jules C says, so suddenly not calling spades. I mean, we can call spade if you want, but we know what's going to happen. Yes, we also remember what happened the last time the Pentagon was going to get audited. There was a problem. So now the argument is the warrants were unconstitutionally broad. The warrants themselves were also unconstitutionally broad. The charges here reflect an extraordinary legal theory that Diddy himself was a criminal enterprise and that his businesses were all part of the conspiracy. I mean, it kind of like Jeffrey Epstein was a pretty good example of it. That theory is alleged in the indictment and reflected in the warrants. The government essentially took the position that everything about his life is evidence of a crime. Well, maybe he's like Destiny and everything he does is about gooning. Maybe Diddy's a gooner. No, chat, no. Oh, no, that means Hollywood's full of gooners and coomers. Oh, no. That's worse than the vampires. Now, oh, God, see, you know what could be even worse? If they're interdimensional potbelly goblins and psychic vampires that are also coomers and gooners. We are so screwed if that happens. I don't know how you kill a psychic vampire that likes to goon. Do you? No, there's going to be no way to kill that. That's unstoppable. We're in trouble, chat. We are in trouble. Oh, no. Oh, no. Oh. This is bad. This is so bad. So, Anyways, in a series of warrants, it thus thought let's get back to this. In a series of warrants, it thus thought authority to search and seize everything in his iCloud account, his residences, his cell phones, and his hotel room. The only limitation was that evidence had to be related to the subject offenses. But because the theory his entire life is a racketeering enterprise, there was no limitation at all. Well, yeah, that sounds like a problem. They talk about this case implicates the central concern underlying the Fourth Amendment. The concern about giving officers the unbridled discretion to rummage through at will among a person's private effects. And that's Arizona v. Gant, chat. And Gant is, I think, a search incident to arrest, I think. Hold on. Arizona v. Gant. Let me see here. Yeah, because Gant was already removed from the car and they searched it. And Gant was a bit of actually, Gant's a very interesting case. I forgot about this, the way he got arrested. So we'll cover that at some point here. Nate Matthews, Arizona v. Gunt. The Rot Search Seizure! Arizona v. Gunt. That'd be great. That'd be so bad. Jules C says, cool if too broad, then redacted is good, correct? I mean, I'm not sure what you mean there. I'm a little confused. I must have missed what you were saying above it. So we'll get to that in a second here. They say this is exactly when the warrant's unlawfully allowed. And they say Fourth Amendment forbids general warrants. Yes, the general warrant, chat, was a warrant the Crown could issue for you saying, we're searching everything. For what? We'll let you know when we find it. They would secure a warrant to search your property. For what crime? They didn't have to. They could just search you. Any valid warrant must state with particularity. Yes, the place to be searched and the things to be seized. The purpose of the particularity was to prevent government from using broad warrants to rummage through a whole person's life. The chief evil that did this was conducted by the British under the authority of general warrants. Yes. And I've seen a copy of a general warrant before. It literally just says, you can search him and his property for evidence of crimes. Just search. Look, find something. And the warrant must at a minimum must satisfy three criteria. It must specify the offense. It must specify and describe the place to be searched. And must specify the relationship between the items sought and the designated crimes. In addition to those three general factors, there are also circumstance-specific considerations that bear on legality. They say, for example, a warrant that fails to indicate a reasonably specific date range can be unconstitutional. And they say, moreover, the search and seizure of electronic devices raises additional concerns. The seizure of such devices can give the government possession of a trove of personal information about the person to whom the drive belongs, much of which may be entirely irrelevant to the criminal investigation. I mean, think about it, chat. Think about how much is on your cell phone nowadays. It's literally, you could look at this and figure out a lot about a fucking person. You could figure out a lot about a person with one of these. A lot. Oh, Chinny, you have a question here. I'm going to get to that in a second. We'll get to that here. The answer really is no. They say a cell phone would typically expose the government to far more than the exhaustive search of a house. Because a phone not only contains a digital form many sensitive records found in the home, but contains a broad array of private information never found in a home. It's true, these devices contain the privacies of life. Warrants looking to seize and search the devices create very serious risk that every warrant will become, in effect, a general warrant. Now, the Second Circuit has held that warrants lack meaningful parameters on an otherwise limitless search are invalid. And they say the core abuse the Fourth Amendment sought to prohibit was the general exploratory rummaging in a person's belongings. And they say that is true in a person's home and as to the belongings on a cell phone. And that's true. I have the right to protection in this as well as my house and my car. But there are going to be times where the automobile exception kicks in, but you still have to have probable cause. They say in this case, the government sought and received authority for general exploratory rummaging through the entire physical and digital life. The warrants were limitless. The government's list of items to be seized was pages long and stunning in breadth. The government claimed a right to seize, among other things, here we go, the evidence of Diddy's location or anything reflecting the location of any co-conspirator or witness, which according to the government seems to mean anyone who ever worked for Diddy or went to a party. That's pretty broad. At Diddy's location, okay. Well, in what situation? What time? What time frame? Utility bills, mail correspondence, and an address book. Well, the utility bills might be just to show who owns the house or what's going on there. Although in Diddy's case, I'm pretty sure it's probably in an LLC. I doubt there's like, Pacific Gas and Electric bill going out to Diddy, or Diddy gets a Spectrum cable bill to his house. I'm sure that's done a little differently there. So. But that's interesting. All calendar scheduling information, including travel records. I mean, that gets to be pretty broad if they're trying to argue he's done things okay, but everything? And as far as the travel records, they could probably subpoena, because he probably flew everywhere, his plane, all that stuff's filed with the FAA. So you could secure it other ways. All financial records, including bank statements and credit card statements, plus all cash, property deeds or titles, or anything related to property ownership, plus any evidence relating to online financial accounts. I kind of get the feeling they learned a lot from the R. Kelly case and put this together. Any sex toys, here we go. Sexually suggested clothing, whatever that means. I love how that's in there. Plus any medical supplies or other material related to sex, plus any bodily fluid or other material that might contain DNA evidence. That's where they took all the baby oil, chat. All the baby oil. All the sex toys. Yeah, it's not a toy, it's a tool. It's very serious. Any communication with any former sexual partner. Now that becomes a problem. Are you arguing that every sexual partner of Diddy's was a victim? How many sexual partners has he had? Why do you need to know about every sexual partner? That becomes a privacy thing. That's where it's like, okay, that's a lot. The calendars of scheduling information, that's a lot too. Because you can learn from a calendar or scheduling, especially somebody like Diddy, what he's doing in his life. Even if there's abbreviations for things, you can piece together someone's movements. Someone like Diddy, his day is fully planned a lot of times. Couple that with the location issue. Yeah, that's a bit of an issue, chat. That's a bit of an issue here. I'm going to be interested how the government responds. So they talk about any communication related to the charged offenses. Well, yeah, if you're taking notes on a criminal conspiracy, that's going to be fair game. Which was, as noted, incredibly broad. With any possible victim, co-conspirator, or witness. Well, I mean, like, if you're talking about straight up committing the crime, I don't see why that wouldn't be an issue there. So I don't know there. So they say corporate records, including organizational and ownership documents and employment records. I mean, that's kind of broad. It's a pretty broad one. Any digital device that might contain evidence. That means literally everything. If he had a smart home, he could take everything that's in the walls too. I'm assuming Diddy probably had a smart home. Like his TV. I'm betting his TV could contain digital evidence. I mean, think about all the things that could contain digital files in your house. All the things. Like, you'd have to basically strip all the shit out of the house. That's a bit much. I mean, that might contain evidence. I mean, that's literally fucking everything. These descriptions are often written with catch-all phrases with regular use of phrases like such as, including without limitation, and including but not limited to. Yeah, those are bad. When you have including without limitation, that's never a good phrase you have in a thing there. That's never a good thing. That's never a good phrase to have. The list above is not even a remotely complete list of what the warrant sought. I mean, God, think about all the shit they did seize. It really sets forth some of the high-level categories targeted by the government. The government warrants, the warrants to search Diddy's iCloud and his cell phones were similarly broad. As to what information it sought, the government may have just said everything. It sounds like it. The iCloud warrant sought the ability to search anything stored in the accounts. That's a lot, chat. The cell phone warrants, both the initial warrant and the subsequent September warrant, sought all communications, photos, documents, calendars, location data. I could see the location data being an issue, but the travel records, financial records, call records, so on, anything related to the subject offenses. That's well, that's something, chat. That's a bit of a thing there. So, huh. That's So. Oh yeah, here's a great so we'll save this for later. But yeah, somebody did find a in the local Discord sent a thing where they have a picture of the Epstein pages. But yes, it's gonna be literally a black line through everything. So what are you guys talking about here? If he's not going to upload sex tapes to the smart TV, no, Anderson Cooper. But like, what did the smart TV record? Like, did the smart TV, was it Bluetooth? Did devices hook up to it? I mean, there's all kinds of stuff that could have been on there. If they're going to search for everything, that creates a problem. Eric is saying it's for the security videos. I get that. But you know, like, who knows what they took? Who knows what they took? If they were looking for security videos, they could say any cameras, DVRs, hard drives, anything that was used in conjunction with the storing of security camera footage. You could do it that way. But when you're doing this broad, like, all digital data hoovering, that's yeah, anything you can run Doom or Skyrim on. Yeah. So there you go. Jefferson Post says they might have a special master for the digital searches. It's already too late. The government's already gone through everything. The time of that would have probably been at the time it all happened. Seeking a search, a special master for all that, but yeah, it's too late now. The government's already gone through everything. Even if they had a taint team, kind of like what had Trump's thing, but except there's no taint team here. They've searched through everything. They ran it all through. It's been run through, chat, and put away wet. But that's a good question, Jefferson, of doing that. You can't do it. Like, you gotta get a special master in right off the bat. And that didn't happen here. Yes, your guys' Hella's favorite word, taint. It says, because the subject offenses were defined as including all of Diddy's businesses, his households, and his relationships with his girlfriends over the last 2 decades. Okay, that is ridiculous. His girlfriends over the last 2 decades? Oh, buddy. That's insane. Like, any girlfriends he's had in the last 20 years, I bet he's knocked a lot of boots in the last 20 years. That was that's a problem. That's a problem. Yes, it got Bonnie Blued. Yes, Diddy's information got Bonnie Blued, but yeah. That's highly problematic. That's extremely broad. So they talk about United States versus Way. Do you know Way? The judge held that similarly broad warrants were unconstitutionally broad and suppressed the evidence obtained through the warrants. They keep citing this case, and I'm assuming they have personal knowledge about the facts in that case or were involved in it. Way involved securities fraud offenses, and the government obtained warrants to search both his residence and place of business. The warrants broadly sought any and all records or evidence that might be related to the offense, including financial records, bills, messages, travel records, photographs, computers, and cell phones, and so on. Indeed, the broad list of items to be seized very much resembles this case. The court ruled the warrants were overbroad and therefore illegal. Several key reasons undergirded the ruling. Although the warrants generally identify the crime as securities fraud, the categories of documents were so broad and numerous to be consistent with the investigation into any form of financial crime. More importantly, the warrant set forth expansive categories of often generic items subject to seizure. Several of the catch-all variety without crucially any linkage to the suspected criminal activity, or indeed any meaningful content-based parameter or other limiting principle. They say in way, the property was not illegal contraband. Rather, it was property in lawful use the government only vaguely suggested might be related to specified criminal activity. Yes. And that is a thing. So it's one thing if you find cocaine. We know that's illegal. It's contraband. You're not allowed to have it. It's a contraband item. But Diddy's Apple Watch, his cell phone, who knows how many digital devices he had? Probably 1 million of them. Not all of those are automatically allowed to be seized. All Diddy's boyfriends. Yeah. Oh, no, chat. Oh, no. They got to go check Bieber out. Oof. Poor Bieber. They say, in way, as in way here, the warrants lacked any meaningful temporal limitation on the items that could be seized. Now, guys, remember, like, this is obviously differences in sophistication and whatnot, but think about Nick's case versus this. They said they're looking for cocaine and cocaine accessories, drug paraphernalia, and they listed out some drug paraphernalia. They listed out the drugs they may be looking for, included any other illicit substances. But remember, it's fairly specific, and you might say, well, those are broad. Well, this is pretty broad up here, the shit they were looking for. And they say at bottom, the warrants in way violated the Fourth Amendment because they authorized the seizure of sweeping categories of materials and lacked any practical tool to guide the agents in distinguishing material items of evidentiary value and those obviously devoid of it. Yeah, and here's the thing. The warrants here are even more infirm. Whereas the warrants in way unauthorized unbounded search of the defendant's business affairs only, the warrants here authorize unbounded search of his business and personal affairs. The warrants here allow the very sort of general exploratory rummaging in someone's belongings. And it says, nor can the government evade the Fourth Amendment's limits by listing that Diddy himself was a sort of criminal racketeering enterprise, and therefore all evidence his business was relevant to the crime. If such a rhetorical trick were allowed, the Fourth Amendment would lose all meaning. And then you always include that when you're in a suppression. You're like, if that were to happen, the Fourth Amendment, if you allow this, judge, the Fourth Amendment has no meaning anymore. And this is going back to England, chat. Lord Chief Justice Holt once famously challenged a prosecutor. Hold, what are you doing now? Are you going to arraign his whole life? And this is from the Old Bailey. This is in London, where they had trials from 1692. Good. This is exactly what the government did here. It charged Diddy's whole life as a racketeering enterprise and then obtained a warrant to search it. The iCloud warrants, the warrants to search house cell phones, and the Park Hyatt warrant weren't individually and collectively exactly the sort of warrants the Fourth Amendment sought to prohibit. And it says, in conclusion, they want to suppress the evidence and all fruits obtained from the warrants as fruit of the poisonous tree, which is correct. They say on the alternative, and at a minimum, this court should order a Franks hearing to hear additional evidence and determine whether the warrants were improperly obtained through deception. Done by Alexandra Shapiro. And this is done by one of the other attorneys. He's got more than one firm working with him. Shapiro, Arado, and Bach, LLP. He's got Mark Agnafilo. That is the that's the lead attorney here, but these people Driscoll wrote the motion, or Shapiro wrote the motion. Then he's got another one here, Anna Estavo from another firm here. So Diddy's got multiple lawyers on his team. And notice the other attorney that withdrew is not listed here. We'll talk about him tomorrow. We'll talk about his case, the situation tomorrow. Mario says, someone billed 3 hours searching for that 1692 case. Yes. And so did the partner. Yes. Now, here's the funny thing. That's something they probably already had on stock. Like, when you find quotes and you see these things, like, I'm not going to lie, chat. I'm going to find that. I'm going to keep it, and I'm going to save it in my file of, like, good things to throw in motion. But yes, I'm sure they had it on stock and they kept using it. I'm sure they kept reusing it. And yeah, right now, chat, I'm going to go ahead and save that. We're going to go back here and I'm going to use Snagit, and I'm going to snag it and then I'll save it later. We're just going to go boop and I'll save that for later. You might say, wow, do you guys really do that? Yes, that's how we do this. Everything is plagiarized. The Park Height is a nice hotel, yes. Anderson Cooper says, I met Terry Garagos, yes. Law is the one field where plagiarism is a compliment. Yes, 100%. All right, chat. So now we're moving on here. We got to catch up on some things. Real quick. Chewy Show, I saw you post this. Yes, so Pam Bondi claims she's releasing the Epstein tomorrow. I told you guys I wouldn't post in Discord all day if I was wrong, and it isn't a nothing burger. Well, I mean, like, really, it's probably going to be this. Just the whole way through. So we'll see. We'll see. I hope I'm wrong. I hope I'm wrong. But thank you, Chugi. I appreciate it. I take a good sense if he has money to hide from the world, why is he worried about the past cases being aired? Because he shouldn't have to. Diddy wants to go out and be an entertainer and be a businessman and do all the Diddy things he was doing. He wants to have his freak offs and he wants to have his baby oil conventions. The fact that you can, you can afford to go live as a hermit, that doesn't mean you should have to. He has the right to privacy, like if all this crazy shit's coming out. Eric Fulton says Diddy and Jesse Ventura. Did I say Jesse? I thought I said Cassie. Eric Fulton says thermite baby oil. That's right. They smeared all the women in the freak offs with Diddy and thermite baby oil. And then Diddy painted them with something else. Oh. Tim Pool, the beanie warlord, is saying 10-year-old information. 10-year-olds are notorious liars. Oh no. Oh no. Nate Matthews says, no, Sean, she's a Virgo. She would never fumble the bag. Ree! Oh, we got the Cassie Ventura stands already. Eric Fulham says, redeem the files, sir. Cash Patel can't help you redeem now. Yeah, said Trump once says oopsie poopsie. Yeah. Well, we fed him in the wrong machine. Sorry. And Jefferson Post says Melanie Mack is going to chastise them all. Yes. She'll fix all the gooners and coomers, although she came from the gooning and cooming. So how could she do that? She came from them. Literally. Adam's saying, whatever happened to all those cops that dumped all the lockboxes on the floor in a bank? Oh, you're talking about the private lockbox case, like the U.S. Vaults case. Let me see here. I think we covered this a while back, but I'm pretty sure we did. The Court of Appeals said that the FBI violated the rights of everything that happened there. And they talk about the Institute of Justice. They went ahead and they won their case. With the U.S. Vaults thing, like they got thumped. By the Ninth Circuit. So, that was a thing there. So they had to destroy all the records and they had to turn over a lot of stuff. They had to return things. Pretty much everybody got their property back at that point. So that was the good news. We covered this already a while back. I think that was a Thursday night show topic. But yes, that's the ones you're talking about, that's what happened. Chinny is saying, is it easier to get a Franks motion in federal court? No. I mean, like maybe, but ultimately at the end of the day, remember, the government is very protective of the government. You suppressing evidence, it's really hard anyway. Here's the thing, you may have valid reasons to do. It's kind of like when I talk about appeals. You've got a banger of an appeals case. The court says harmless error, or they distinguish it. They say lol, don't care. I wish I could tell you that was the case, but no, it's not. Oh, wow. It is raining. Like, it is pissing down rain outside. Wow. Interesting. Jefferson Post says Tulsi's on an anti-gooning campaign. Oh, yeah. Don't goon at me. Is this the time for a Franks hearing? Maybe. I mean, Here's the problem. I don't know what wasn't said. We don't know what wasn't said. And this is going to turn into the defense saying you lied, and then the government saying, that's not true, and saying, no, he's wrong. I have a feeling like, I think a Frank's motion probably be a good, Frank's hearing would be a good idea. If this was completely bullshit, these guys would get in trouble because a federal judge will not let you fuck around like this. So I think there's a there. I bet there's some sort of information there that's critical. Baby oil can't melt steel beams. Does that mean Diddy's getting off? Maybe. Maybe. It's very possible. It's very possible. Yes, law is the one field where plagiarism is a compliment. Yes, it is. Yes, it is. Mario is saying absolutely true. Okay, good. You're agreeing with me. Yes, the good thing about these, and that's the one thing here. This will lead hopefully to good case law because Diddy's attorneys, he's got a unlike Diddy is probably one of those people, unlike the government, that has an unlimited war chest. Diddy could spend $100 million. The government, they might not be able to. So Diddy can spend $100 million on attorneys, and they will tear shit up. But the thing is, these attorneys won't do it if it's bullshit because they can get sanctioned. They can be in trouble. They have to be in that federal court for the rest of their careers. So they're not going to shit in the pool. Some guy with cancer says the Trump Mar-a-Lago warrant was super broad. It kind of, but remember, those haven't been fully released yet. So I want to see the affidavits because the affidavit really is the big thing there, where like the affidavit without redactions is what I really want to see. But they only looked for the boxes where the documents were, and they looked like where you could store a document. But that's the thing. Like I could store this piece of paper, like this, manual for the tank, and like where can I store a piece of paper? Basically anywhere, and that's the problem there. So yes, those guys had an excuse to go sniff Melania's panties. Yes, this worked out great with the Alex Jones case. Well, Diddy's actually got all the money. Alex Jones had a lot of net worth, but it was tied up in things. Trump once says it's raining like a mofo in Youngstown. Yeah, it's raining really bad up here by the lake. Even though there's rain on the screen, I could see it puddling up in the street and smashing around. The most annoying thing about Hunter getting pardoned, the firearms from the violation never got fought all the way. Yeah, I know. I would have loved to have seen Hunter been the guy to take care of it. And Joe Smo is saying over in Rumble, has Diddy been running freak-out parties using his girlfriends for over 20 years? We don't know. We don't know what the hell, like, all of his sexual partners. That gets to be ridiculous. Somebody like Diddy probably had sex with a ton of women. Like, at some point, yes, there's a lot of overbroad, like, there's a lot of questionable stuff here. Some of it's not as questionable, but a lot of it is. But is the court going to do anything about it? Remember, guys, how many times do I tell you, you can have a great case and the court shoots it down anyway. They said girlfriends, not sexual partners. Well, what do they define as a girlfriend? How do you define girlfriend? What's girlfriend mean? Girlfriend doesn't have a legal definition. Phone, I know what a phone is. There's a definition for a phone, a reasonable definition for a phone. I know what the reasonable definition for a pen is, or un stylo, if you speak en français. Like I know what those are. What's a girlfriend? I'm sure girlfriend turned into anybody he's fucked. So that's an issue here. That's an issue. Yes, the attorney is Shapiro, not Spiro. It's not Alex Spiro. He's busy defending Eric Adams, you guys. So yeah, there's a lot. Like I said, there's a lot of questions here. There's a lot of questions. And then William Wallace says it's well, thank you for being over on Twitter, saying I hate the movie Starship Troopers with a passion. Yes, Paul Verhoeven basically dropped a Cleveland steamer on Robert Heinlein's grave with that movie. Book is way better. Yes, the book is 100 times better, and it's funny because Paul Verhoeven did the movie wanting to be fascism is bad, but just like the Far Cry songs, keep your rifle by your side. Everybody's like, no, this is based. I love it, and I'm sure Paul Verhoeven got very upset that people kept adopting it and thinking it's cool. Brewberry says, is it gay if you have sex with men but relationships with women? Yes, I got news for you. Yeah, that makes you gay. That's gay. Yes. Scott says, I'm still waiting for my hug voucher in the mail. Well, keep waiting. It's on the way, I promise. Garrett says here, and the cops are done swabbing Diddy. It's like, so Larry's on the bed swabbing Diddy's ass cheeks. Oh, no, chat. No. You guys are ridiculous down there. Then Anderson Cooper says, pro tip, if there's a protective order on a case, especially if you're in the state of Utah and the District of Utah Federal Court, learn how to use it and don't accuse the other party of ignoring it when it's your own mistake. Yes, if your name is Russell Greer, that is a very common outcome that'll happen. If your name is Russell Greer, I'm sure that happens a lot. Very good advice, Russell. Did he have daily colonics? Somebody asked that earlier. I was like, what the hell are you talking about? Sleazy says Verhoeven accidentally got it right. Yes. Verhoeven was accidentally based in that movie. Girlfriend is just another name for your live-in nanny. Yes. Yes, Spiro was representing Jay-Z. Yes. John Robertson, his job tonight, finally. What happened? Don't just say that. Send me links. There's something to talk about. Kent Madison saying, oh, based. Oh, here we go, chat. Oh, so the United States, Supreme Court of the United States, Department of State versus the AIDS Vaccine Coalition. It is ordered that on the February 25th, orders of the United States District Court in 2 cases are hereby stayed pending further order. This is the one where it was due by tonight. Pending further order of the undersigned or of the court. It's further ordered that any response to the application be filed before noon on Friday. Justice John Roberts finally showing his spine just a hair. But remember, chat, he might screw us over like he did with the TROs, where I was completely shocked he punted all the way. So right now, mega based. For now. There we go, chat. See Discord. There we go. You count the girlfriends by subtracting the neuters, one-offs, and orgy participants. Well, how are you supposed to say that? How do you know what's a girlfriend? He might have a different term. Ginger says the laugh is scaring you. I didn't show it. Oh, hold on. Shit, sorry. I thought it showed it. Here you go. Supreme Court, United States, Department of State et al. The orders out of the District Court Columbia are hereby stayed pending further order, and that you have until Friday at noon to file. So we'll see what this means. I don't think it's going to lead to anything eventful. We're still screwed. But, for now, the Supreme Court found its balls. They found the ball sacks, chat. What is this? Oh, wrong month, chat. On the 28th, where am I at? The morning. Okay, there we go. So, the Diddy case is great PR. That's why they're trying so hard. Yeah. Yes, I'm back over 25K subs, chat. Finally. We're back. We were back, going back towards the sun. Oh. So there we go. Valhalla, how you doing, man? Yes, hit the like, everybody. Yes, did I see Senator Sheldon Whitehouse's wife was on the take of a ton of USAID money? Yes, that he was voting for. You're like, wow, isn't that a conflict of interest? Just a little bit of one, just a little bit of one. I mean, like, really? Yes, and then the NSA is full of troons talking about, sex changes while they're at work. It's like, great. That's what we want in the intelligence community. Stable people like that. So, KLF says 496 until you get 25K. Really? Really? Well, there you go, chat. Give KLF a shot. Get up to 25K. Yes, they're gooners at the NSA Goon Squad. Literally, they're goons in more than one way. Is it possible for the DOJ to sign on to one of the lawsuits on Second Amendment grounds? They could, but they probably won't. Nate says I have 43 subs. Well, you can. You got to start somewhere. Yeah, show some love for KLF. Let's get some subs. Chat. EDW Raptor says he'll only subscribe if she goes on a date with Ag. Oh. So the other services use the chat program. The NSA just develops it. Okay, so all the glowies in the intelligence community are degens. Got to get rid of them all, chat. Oh. Yeah, I didn't know KLF made stuff either till J-Rock was plugging it earlier. So. But yes, thank you, EDW. I appreciate the super chat. So. I heard the chats are online. I have heard that too. Like, you can find them. Yes, you can. I saw them. They're a little very disturbing. Very disturbing, chat. All right. Well, with that said, chat, I think we are at a point here. We need to get off the road. It's been the glowies where I only drive at night. Well, to quote the great Uncle Terry, I mean, Uncle Terry did have it right.
The CIA niggers glow in the dark. You can see them if you're driving. You just run them over. That's what you do.
You gotta do, chat. You gotta run over the glow. You gotta run over the CIA guys. It's how you find the glowies. You just hit them with your car. It's what you do. Yes, Territory. Yes, you guys are possibly Lutheran Castle Doctrine. Yeah, I'm gonna go over that tomorrow night. It's very interesting. Very interesting what's going on in California. So that's one of the other things there. Let's see what else. Hold on. Where's play the other one where he calls the dude on the phone. No. Because yes, Uncle Terry called everybody like that. Nico says, "Oh, I thought that was Ray DeVito for a minute." No, that's Uncle Terry. That's Terry Davis. That was Terry Davis. He made his own operating system, Temple OS. Go look him up on Count Dankula. He'll help you out a lot. Did I see the GWP article on Obama? No. Did not. Nope, I did not see that yet. So, no, I did not. Rip Terry, thoughts and prayers, yes. So, all right, chat. We're all done. Like I said, we got to land the plane here. We got to go. We got things to do, stuff to do around. So we will be live tomorrow night, chat. We got a bunch of stuff we are talking about, including Diddy's attorney withdrawing. Adnan Syed, there is an update on his case now. It sounds like we're getting close to the case finally being resolved. There's an interesting case on the 11th Circuit. They had to resentence the guy who was going around beating up people he found on Grindr. The woman who tried to steal Graceland got sentenced by a court. And California's attempting to repeal self-defense. There's going to be a lot going on out there. A lot of interesting stuff, chat. So just keep your eyes peeled. It'll be tomorrow night at 9:30. And we'll be going over some of the Trump updates. There's a lot of them, so it'll help. And but yes, guys, tomorrow night is the Thursday night show. We'll be live at 9:30 Eastern, as always. And are you going to go over Richard Glossop? Yes, if I have time to read through that, I will, because it is an interesting case. It's a very interesting case. The public library in Baton Rouge is sitting on $100 million in cash. What? How the hell do they do that? How many late fees do you guys not return your books over there in Louisiana? What are you guys doing? Demon's Wrath says, why 9:30? I thought 8:30 was usual. No, it's always been 9:30. Always been 9:30. I think there's one time we started earlier, but then there's also one time we started later. But almost every other time, it's always 9:30. Always 9:30. All the libraries sit on cash. We take cash from the parish libraries to build jails. What the fuck? What's going on in your libraries? Yeah, wait, you guys read? Yeah. What do you, are you selling drugs out of your libraries? What are you doing down there with them? I mean, you're laughing. I'm not. Why didn't the libraries have $100 million? So they sold old editions of Mein Kampf. I don't know. Anyways, chat, we are all done. We are going to land the plane here. The wheels are touching down. Please make sure your trade tables are in upright lock position. And clap once we land so you know we made it in one piece. So good night, everybody. Take care. And remember, next time, just because you did it does not mean you're guilty. Did he, though? I mean, I don't know. This is pretty convincing, but we'll see. We'll see. We'll see. So good luck, Diddy. You're going to need it, man.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?